Hello. Good afternoon, everybody. Are you able to hear me?
Sir.
You're able to see my presentation?
Yes, sir.
Okay, good. Thank you.
Thank you, sir.
Yeah, great. My dear students, happy to come in contact with you again after a long time. Hope you are all enjoying the course. So most of you by now, you are aware what are the different types of intellectual property. You know, can someone quickly tell me what are the different types of intellectual property rights? What are the different types of intellectual property rights? I'm not able to hear from any one of you. What are the different types of intellectual property rights? We have completed already 6 or 7 classes. The first class itself, I myself mentioned to you, briefed to you in my first class, what are all the different types of intellectual property rights. As a student of IPR class, you should know the basics. The fundamental question is, How many types of intellectual property rights are there, or what are their names? Tell quickly so that we can save time.
There are 7 types of intellectual property.
Rights, very good. 8 basically. Yeah. Tell me what are the names to see.
It's copyright, trademarks, patent,
Yeah.
industrial designs.
Good. At least to some extent, you should be, all these things should be on your fingertips, when you attended the classes, you have been listening. Now there are 8 types of intellectual property: patents, copyrights, designs, trademarks, geographical indicators. Then what else? Farmers' rights, plant varieties and farmers' rights. Then we have trade secrets. Trade secret is also a kind of intellectual property right. These are the 8 types, or 7 or 8 or integrated circuit layout designs also is another form of intellectual property. So with all these things put together, there are 8 types of intellectual property. So once you have created intellectual property, how do you create? By doing research. Once you have created intellectual property, then what is the next step? It is protection. How do you protect it? You all know that. First, creation of intellectual property. All these things you can create by doing a research, by identifying the need, by identifying the novelty, inventive step, and industrial use. These are the 3 fundamental criteria for any of these rights to be acquired or granted by the government. So once you fulfill all that criteria, you apply to the government saying that you need rights on the knowledge what you have created, the intellectual property what you have created. Government also has got a certain process to evaluate and give the rights on that knowledge to you. So that is what we call protection. Once you create and protect, what is the next step? Logical step is put that knowledge into use. That process, what we call is licensing or commercialization of that IP rights, what have been granted to you by the government. So this is the IPR life cycle. That's what we call the IPR life cycle. Will have 3 phases basically: IP creation, IP protection, and IP commercialization through the process of licensing. These are the 3 important steps you should remember. And to promote this IPR culture in our country, the Government of India, the Ministry of Industry and Commerce, under the Department for Promotion of Industry and Internal Trade, that's what we call DPIIT, under which our IPR chair was also established in Andhra University. They are the nodal agency to promote IPR culture in our country and to generate that kind of IPRs, protect them, and help in commercialization. So Government of India through DPIIT brought out, a national IPR policy 2016. If you want to achieve anything great changes or great performance, you need to have a policy, So if suppose you wanted to, Andhra University wanted to produce a great human resources, the university has also policy, to produce, how to make a good human resources, a policy will be there. Policy is the basic fundamental roadmap or approach. So for strengthening and for creating that kind of awareness and culture in our country, the Government of India has brought out a IPR policy. So the major objectives of IPR policy is that first and foremost is to create IPR awareness. So awareness is important for anything to achieve in anybody's career or a business or a growth. So in this process, IPR awareness, we the government encourages outreach and promotion programs. Like organizing workshops, seminars, exhibitions, all these things are a part of the IPR awareness. So Government of India encourages various organizations to create IPR awareness by organizing such kind of events. The second important objective of IPR policy is the generation of IPRs. How do you generate IPRs? How do you generate IPRs? By identifying the problem and trying to generate develop a solution to solve that problem. That is how we generate IPRs. So how do you identify the problems? By way of observing the society, by reading the industry annual reports, industry problems, by attending the conferences where many people say these are all our problems we are all facing, So that is how the problem will be identified, right? Research will be undertaken to solve that problem, So once it is proved, then the problem has been solved with a particular kind of a solution. If that solution has got a potential to generate business, for example, you developed a technology for solving that problem, so you apply for the IP rights and you got the rights, then the next step is protection. We are going to follow that also. The generation of IPRs also is one of the objectives of the IPR policy. So what is required to stimulate the generation of IPRs? So many funds or grants, in various departments of the government have been created. So if you have got a problem statement, if you wanted to develop a solution, you can reach out to government, various departments and different ministries, and the governments also sometimes announce the problems, national problems, and they call for proposals. So you can submit, get the funding, do research, develop a solution, and go for protection, and you can also commercialize it. That's about the IPR cycle, what we talk, The legal and legislative framework, this is also very, very important. Once you generate a knowledge technology, it needs to be protected. If it needs to be protected as per the law, you also should have a strong legal and legislative framework is required. So to have strong and effective IPR laws are required, which balances the interests of rights of owners and larger public interest. These laws should be in such a manner that the rights of the inventors, and the public interest should be properly balanced. That is what is very, very important. Then only both the parties will be benefited, the inventors as well as the industry, The fourth aspect of the objective of IPR policy is that IPR administration and management. See, you have created this knowledge, but someone has to administrate, someone has to manage it. So for that also, there are bodies like Indian Patent Office, the DPIIT. So all these people also should have kind of a policy. What is their role? What are their responsibilities? So for that to happen, Government of India has established Indian patent offices across the country, mainly 4 regions, Calcutta, Delhi, Chennai, and Mumbai. All these 5 places, the Indian patent offices are there, and they basically manage the entire IP generated in our country, so those offices also requires technology, they need to be modernized, and the government has to put adequate number of examiners, controllers, so that whatever applications they receive, they dispose of fast, by way of granting IP rights to the inventors. So that is also one of the objectives, strengthening the IP administration management. Then fifth step is an important objective is commercialization of IP. That's what we are talking today. No, it is also part of the IPR policy of Government of India. Commercialization of IP means monetizing the IP. By using your IP, you create wealth, you create employment opportunities, you bring new products and services to the market. So that to happen, what needs to be done at the policy level? So Government of India also has got several committees, institutions to help commercialization of IPs what have been granted to the individuals. Then another important aspect of this IP law is that enforcement and adjudication. If somebody copied your technology, your patent, there should be kind of a mechanism in our system, to enforce and adjudication. Somebody copies the way your property, personal property, or the land, building, gold is stolen by someone without your permission. So kind of remedies are available. There are both civil and criminal remedies are available from the court. So same way, if your patent, or copyright, your trademark is copied by someone else, you can also approach to the courts. So that mechanism is also very, very important. So Government of India is also strengthening that enforcement and adjudication process also as per the law. And human capital development. If all these things to happen in a faster pace, what is required is the human capital. The human resources are very, very important. So Government of India has also put as one of the objectives of the IPR policy is to develop strong human capital in our country, to strengthen and expand human resources, institutions, capacities for teaching, training, research, and skill development. So many organizations in our country are implementing this policy. We all know that how to get a patent or your trademark or a copyright or a design. As I told you, there is a systematic procedure. The Indian Patent Office, has set out a process. One has to follow that. So, in case you probably might be aware this process also. The process is in a simple form. I put it here. If you want to get the rights, what is need to be done? You need to file your application disclosing what is your invention, how it benefits the society, what is the inventive step, what way your technology or invention is different from the existing current knowledge, highlighting all these things. You need to, there are forms are available in the Indian Patent Office website. So you need to fill them, disclosing in that all that knowledge. Then that will be published. For every activity, there is a timeline given in the Indian Patent Office website also. So it will be published. Once it is published, thereafter you have to apply for a request for examination. So you have to ask the government of India, please examine my patent application. So for each activity, there is a time, there is a fees also you need to pay. Once you file a request for examination, patent office or the IP office will examine it and issue the first examination report. So another step happens before going for a final examination and grant. Once it is published, anyone interested in this technology, interested in this knowledge, they can also oppose, saying that no, patent should not be granted to this person. Patent should not be granted to this person because this knowledge is already in the public domain. Everybody knows about it. There is nothing new in this, so patent should not be given. People can oppose, and they have to provide evidence to that effect, what they are claiming. And if the controller is satisfied with the evidence saying that this knowledge is available or is falsely is filing a patent and all, if he satisfies, he will not grant the patent also. So this is what we call pre-grant opposition. Before grant itself, one can oppose. This happens parallelly before grant. So once issuance of first examination report to generally patent office, gives a report saying that this knowledge is already in the public domain, everybody knows, or some people have done it, they give all the references, they will try to argue that your patent is not new, not novel, there is no inventive step. There are some exemptions are there under the Indian Patent Act. Everything under the sun cannot be patented. There are some exemptions. If anything falls in that category, they will also mention, Section 3 and Section 4 of Indian Patent Act clearly mentioned that what are all things not patentable in India. I think Dr. Anandya Roy Chaudhary, my colleague, might have spoken on all these aspects. So based on all those things, he will submit a report to you saying what are all the deficiencies in your application. Then you need to file a response for that, saying that no, all your allegations, all your observations are wrong. Mine is the genuine. These are the results. You need to convince him. Once he satisfies, he will grant the patent. And of course, this examination process, once he inform you why he doesn't want to grant a patent to you because of the following reasons, you need to give your replies to that, and if required, you will call for a hearing, and during that hearing, both the parties will be discussing. Then the patent controller is satisfied, he will grant the patent and notify in the gazette. And the Indian system, even after grant also, people can oppose, saying that the patent is wrongly granted. I also contributed for the patent, but that fellow has not put my name in the patent application. So there are several grounds have been given in the Indian Patent Act, based on which people can oppose it also. If the controller finds, evidence against that complaint, he can even cancel the granted patent also. So that's what, up to 1 year, people can also oppose. So once that opposition is refused, then patent will be granted, or whatever patent is granted, that will be continued. So this is the simplest process, of getting a patent. But as a university, as a research, what you need to do, always better to use some kind of an expert opinion. For that, in Andhra University, we have opened an IPR cell. So anyone, even a student or a faculty, has come out with some kind of a solution for an existing problem. No, you can submit your invention disclosure form to us. It will screen it. Is it in compliance with the Patent Act and procedures? And if we find it is okay, then we get the patentability assessment. If you want to get a patent, you all know by now what are the three conditions you should meet or it should fulfill. One is novelty. Novelty means it should be first of its kind in the world. Inventive step, there should be some kind of technical and scientific advancement in your invention. Third one is industrial applicability or use of that invention. These three conditions are fulfilled or not, we will examine by using some of the patent databases, particularly to find novelty and inventive step. So once we satisfy, we file the application through our patent agent in the Indian Patent Office. Thereafter, the standard process will be followed. So this is the process of filing a patent. This is very, very important. It's a sure question in any of the competitive examinations, where IPR is being tested your knowledge. How do you get a patent? In India, this is the process. You need to file, then it will be published. Then after that, you have to file a request for examination. The examiner will examine and give a report. And if he is satisfied, he may not give any report straight away, say that this patent can be granted. But 100% of the cases, without first examination report and replies, no patent has been granted, in the history. So this is a standard process. You all should know how to get a patent. And coming to the licensing, now we all know that you have created a new knowledge, you have secured a patent on that, knowledge. Then what next? Has been seen in the IP life cycle. Next step is the IP commercialization. So what do you mean by IP commercialization? How this benefits to the society? This is all very, very important again for all of you to know. What is IP licensing? Basically, the process of transferring. Somebody is disturbing. Sira, Ganesh, please mute yourself. Yeah. The process of transferring IP means the patents, copyright, design, trademark, or the remaining things, The process of transferring this IP, developed and owned. If you want to license, you should own it, How do you own it? By way of getting the rights granted to you by the government. So once you develop and you own, that IP or that knowledge by the individual or enterprise or university institution or a research institute to another individual, another enterprise, another university, or another academic institute, or another organization, or another company, to transfer that knowledge with an intent to produce that product or process on a commercial scale through a formal IP licensing agreement, that is the meaning of IP licensing. You develop the knowledge, you develop the technology, and you got rights on it. And using those rights, you can license to others. Once you got the rights confer on you. Either you can use that knowledge yourself, because once that IP right is conferred on you or a patent is granted to you, what is the advantage you get? You are the owner of that knowledge for a period of 20 years. If no one can use that knowledge without your permission. If someone wanted to use it, you have to license it. That is where you got the rights on that knowledge. So those rights only you are licensing. IP is licensing nothing but licensing your IP rights to third party to utilize and produce, manufacture, sell, that product or service in the market. It is like any other standard licensing practice. So IP licensing brings many benefits to the stakeholders, like the people who develop this technology, who owns this technology, and if you want to license it, so what are the main advantages? You don't have to reinvent the wheel by doing a research again. There is already a solution developed and it was recognized. Government gave a rights on that knowledge and the technology, saying that it belongs to you. So since you do not want to use it yourself, you wanted to give your rights to others to use that knowledge, so that by that way you are not able to, you do not want, you are not spending money on doing research to find out a same solution. So that is advantage is that you are reducing your expenses on R&D by licensing your technology, but taking license on a new technology. And also, you can bring that product or service, new product or service to the market very fast. It reduces the time to market. And then new products and services to the market, and it creates employment opportunities, wealth, creation, and overall socio-economic development. If you want to say, for example, you want to establish a refinery in your region by taking a technology from some of the advanced countries which have got less pollution, higher yield, and all those things, there is a licensing involved in that. So the licensor also gets benefit, the licensee also gets a benefit, the economic development also takes place in that region, because of the new opportunities. So therefore, IP creation, protection, licensing, commercialization is a paramount important for national, regional, and global development. IP is such a backbone for the economic development. IP, how this technology licensing happens, you should also know that basically it happens through the technology transfer office, the IP cells established in those institutions, research laboratories, or the companies. There is a separate division in most of the corporates and government offices and ministries and also universities. Like in Andhra University, we have the Center for Intellectual Property Rights, who does all these things. This is what I think the concept of IP licensing should be clear to all of you. So this is how the licensing and commercialization takes place in general, for any technology. So first of all, what happens if a faculty member, scientist, develops a technology? What happens? The TTO, the Technology Transfer Office, or the IPR cell, have an interaction with the inventors, and they will ask, the faculty members to disclose what is their invention in a prescribed form. That is what we call invention disclosure form. This is the basic document through which you communicate your research outcome or invention to the TTO, Technology Transfer Office, or Center for Intellectual Property Rights. Then the office receives this application and they do the standard scrutiny or analysis and the preliminary evaluation. Then a decision is taken what kind of intellectual property right we can seek for that new knowledge. It could be patent, trademark, design, copyright. So what kind of thing we should take, then the decision will be taken. Then those inventions will be selected, then afterwards there will be a conference between the team and the TTO office, and the process will be explained to them. Then what happens? Based on that, we will also decide a licensing strategy and tech marketing, how to market this technology to various companies, entrepreneurs, startups, who are looking for such kind of solutions. Then initial contacts with the companies. So this technology will be, once a patent application is filed, we always do the marketing. We should not do marketing or reveal this knowledge to the public before filing a patent, patent, because once you market it, people come to know, but the novelty is lost. One of the conditions to get a patent is novelty. How do you protect novelty? You should not reveal to anyone until you file your patent application. All these things are very, very important. You should remember as an IP professional. Once you file the patent application, you can do all the marketing and try to get large number of inquiries from various potential entrepreneurs, evaluate them, negotiate with them the kind of licensing fee you want to charge, the royalty, the jurisdiction where the license, in which regions you wanted to give. You wanted to give the entire India or even the world or a specific country. All these things have to be negotiated with the licensee. Licensee means the company or the entrepreneur who is interested to take license from you. In this, you mutually decide all the terms and conditions. Once both of you satisfy, then what we do, we call it a term sheet for negotiation. What are all the points? We will list it out. Then on that points, once you discuss, mutually agree, then we draft the licensing agreement, and you sign the licensing agreement. That is the starting point for a technology commercialization. Once license is signed, you will transfer all the knowledge what you have generated, all the patents what you have got, that knowledge, you share with the entrepreneur or the company or a startup company, so that they will make use of your knowledge and produce the product or the service and bring it to the market. So thereafter it is a simple management. So these are all the basic concepts in the process of IP licensing. So the same thing we are shown here is that first and foremost, the idea to commercialization, what are all the steps involved? Is my idea finding or a research is an invention. Invention, what do you mean by invention? Invention means the Indian Patent Act has already been defined under Section 2 of Indian Patent Act. Invention means it should be novel, there should be inventive step, and it should have a industrial application. If all the three parameters are fulfilled, then only we call it as an invention. It is also a very standard question. How do you define invention? What is meant by invention? What is meant by innovation? So the process of taking invention, the process of taking invention to the marketplace is called innovation. You should know all these basic definitions of invention, innovation, innovator. So the person who takes the entrepreneur is called innovator. So first and foremost is that it should fulfill that criteria. Once that is done, you disclose that invention to your TTO office or to the IPR cell. They evaluate it, whether it is fulfilling all the criteria, it has got the market potential. All disclosures need not be protected, unless there is a market potential for that. Patenting is also quite expensive proposition. It would cost substantial money in India and if you want to secure rights in other countries. So one has to take a very cautious decision to whether to file a patent or not, But the point you should remember is that as per this flow diagram, and patent filing and marketing of the invention, these are the two important stages in taking the idea to market. So what you need to do is you file patent first, then you market about your technology. If you do the other way, the novelty is lost. Patent filing is done, then afterwards you do the marketing. So once your patent filing is done, your novelty is protected from the date of filing. Afterwards, if something comes into picture, that is a different story. Your invention will not be affected. As on that date, no one has published, no one else knows about this technology in the society. So that is the date on which the novelty is established. So that's why you need to protect your invention by way of filing your application first, then you reveal it to the market, go to the press, go to the radio, go to the TV, and all social media. You can use it to create awareness, to create buzz about your technology. But before that, you always file your patent application. It could be provisional application or a complete application. Probably by now you are aware what do you mean by provisional application, what do you mean by complete specification of a patent processing. Once that is done, you market it, you identify many people show an interest, and whatever applications are received, evaluate whoever is the best party, whoever is paying much higher licensing fee to you, you can license the technology to them. Again, this licensing also, there are 2 or 3 types of major methods, exclusive license and non-exclusive license. We are going to talk in the subsequent step. So steps leading to patent commercialization. So like you have licensed the technology, you license your patent. License means what? You given permission to use that knowledge, by third party. So that doesn't mean that the technology has been commercialized and the product has come to the market. There are several steps involved before taking the idea to the market. What are those things? Is there a market for your patented technology or the licensed technology? How large is the market? What is the competition? Is very, very important. Before IP licensing takes place, the receiver, whoever is taking license, because he's paying money as a royalty, as a licensing fee, for getting those rights. So he should be very sure what is the market for that product or service. How big is that market? What is the demand supply gap? All these things are very, very important for you to understand as a technology receiver, technology buyer, or the licensor, licensee. So how far is it from becoming a product? So as you all know, most of the patents are not really technologies. They are just a proof of concepts. You need to develop them further to become a product. The prototype development, validation, testing, all scale up, all these things are required. So making presentations, once you convince, if you need to raise money, to establish a commercial plant. So you need to make presentations before the investors. like venture capitalists, banks, and all those things? Are there resources to further strengthen, demonstrate, refine the invention? Finding partners to develop this IP into products is very, very important. Identifying licensee, due diligence is very, very important. Valuation of IP is also very, very important. Before even licensing it, you should also understand how do you value. For example, you developed a patent, you wanted to license it. You should know to what price you should license this technology. This is not like a government property where the values have been established. It's a new technology which you have developed. It's very, very difficult to estimate the real value of the technology. So you have to make a lot of assumptions. And some via media and based on the experience, one will always decide at what price the technology can be licensed. That is what we call valuation. Then negotiating licensing agreements. Of course, the agreements will have several terms and conditions. You need to negotiate each and every condition. One has to accept mutually, then you sign the agreement. So that is what we call signing of licensing agreement. And after the licensing agreement is signed, you need to raise the money to establish a commercial plant. So you need to find a financial partner or funding agency. And once that is done, you also need to get the regulatory approvals are important before launching the product to the market. And before launching the product into the market, you also need to do an analysis called freedom to operate analysis. This is also very, very important, particularly for innovative products, which products which are under patent protection, very, very important. If someone has already got a patent, say, for example, in America for the technology, and you cannot launch the same product, you cannot sell the same product in the American market. So to know that, one has to do the freedom to operate analysis. So these are the basic routes for commercialization. What are those three basic routes? As I told you, you will get, once you got patent rights, for example, by the government, what it means, you are the absolute owner of that knowledge for a period of 20 years. If no one will be able to use that knowledge without your permission. If somebody wanted to take a permission, that is what we call it is you need to transfer your rights in the form of a license, to the others. But when you want to use that knowledge, produce that product and service, and you want to bring the product to the market, you are the first person to do it. You can do it yourself free of cost. You don't have to pay any license fee to anyone. So the 20 years is exclusive right we are enjoying once patent is granted to you. So that exclusivity will give you a right to commercialize. That is what commercialize yourself once you have got a patent. Or if you do not want to commercialize yourself, what is the next channel? You can license it also. That's what we are all talking about, licensing. Licensing means you are giving your rights to use that knowledge to third party. That is what is nothing but license. So again, as I told you, there are different types of licensing: exclusive license and non-exclusive license. Very, very important at this point again. Exclusive means you will be authorizing only one person in the entire country or in the entire world to use your knowledge, use your technology. That is what we call exclusive. So we are preventing competition to him also by giving exclusive license. Obviously, the exclusive license would be costlier than the non-exclusive. Non-exclusive means, what do you mean? You can give your license, give permission to use your knowledge to more than one party. Any number of parties you can give. Always they will be less costlier. But if you are giving exclusive license, for example, the what I would give an example here, some pharmaceutical molecules, the universities or the national laboratories who develop these pharmaceutical molecules, even for that matter, even your computer chips, there are these inventors or the institutions which develop this technology, they will find out a big player in that field and they give exclusive license to them. So they will not give to others. So that way they are preventing competition. The agency which receives this technology, they can spend a lot of money in the market, for advertising, marketing, and promoting, so that they can capture the entire world market. So exclusive rights gives you that kind of a access to this knowledge, and you will be the sole manufacturer of that product across the world. So that kind of a rights they will get under the exclusive license. Non-exclusive means there will be more than one party who is manufacturing similar kind of product. Then licensing for manufacture and selling, or it can't be licensed. So licensing in the process, once you got license from the owner of the IP, unless you negotiate, it cannot be sub-licensed. You cannot transfer to another party, but relatively they are cheaper and limited period. This is a licensing process. The other channel for getting access to this patented knowledge or technology is that assignment. Assignment is nothing but getting absolute ownership. How do you get absolute ownership? By outright buying of that patent directly from the inventor. It is like buying a car, buying a house, buying a land. That is what we call assignment. You are getting the 100% ownership of that knowledge. But whereas in the licensing, you will not get ownership of that knowledge of the patent, but you are getting only permissions or rights to use that knowledge for a certain period. That is what we call licensing. But whereas in assignment, it's not like that. In the assignment, you are getting the absolute ownership is transferred. So you can get whatever you want. You can further sell it. You can further sublicense it. Because of these benefits, assignments are always expensive, outright purchase, and you get perpetual rights. So this is also again a very, very important slide, understanding the channels or the routes for commercialization. So what is the difference between licensing and assignment? Again, is a very, very standard question, and licensing is a cheaper over the assignment, So some of the aspects in the licensing agreements, the terms and conditions have to be negotiated properly. So what are all the terms and conditions generally appear in the such kind of IP licensing agreements? Of course, apart from defining the parties who is who, which party is licensing, which party is receiving, that is of course always starts with the any agreement starts with that, Then after that there is some various clauses, introduction of both the parties will be there. The third important clause in any agreement is the definitions. Definitions, each and every key word what you are using in the agreement has to be defined under this clause of definitions. Like product or the process, the specifications have to be clearly defined. Very, very important, because when some dispute arises, the courts will go into the definitions clause. What we have defined as the technology or this process or the product, and that it will go only as per that. So it's very, very important for you to define each and every terminology what you are going to use in the agreement, like the process. If you say you are licensing the process, you are licensing the product means what is its physical shape, what is the chemical properties, what are the physical properties, what is the purity, all those things depending upon the product, you need to define its specifications. And the roles and responsibilities, again, you need to define. If the role or responsibility is not defined, in the agreement, tomorrow you may say that this is not my responsibility, this is your, for example, getting a regulatory approval, who has to get, that has to be clearly defined. For example, you have established a plant and there is a environmental pollution control board approval is required. You got stuck because of that. But unless you mention that, in your agreement, you will be stuck. So basically, the environmental pollution will be given to the company only, not to the university or not to the research laboratory. But whatever information is required by the pollution control board, has to be provided by the technology transferring agency or the transferor. So it has to be clearly mentioned in that, otherwise you will land into problem. So whether the license is exclusive or non-exclusive or assignment, what type of license, that has to be clearly mentioned. Geography, which geography you are allowed to manufacture and sell, you may be allowed to produce only in India. You may be license is given to produce only in India and sell anywhere in the world. That has to be clearly defined. You cannot establish a similar kind of plant in some other country unless it is mentioned in your agreement, they will restrict or they will object. So they may give a permission also for that, but you need to pay extra licensing fee. So these are all the conditions you need to understand thoroughly. The licensing fee, the royalty rate, the duration of this agreement, all these things have to be mentioned. Similarly, some dispute resolution, some dispute arises, who takes the responsibility? How do you settle that? Whether which jurisdiction this disputes will be resolved in case, if you go to courts, whether in an alternative dispute resolution mechanism you are proposing, all these things have to be clearly defined in that. And another most important thing with reference to IP is that, you need to clearly articulate in your agreement who is going to maintain the costs of the IP. For example, I am holding IP on my name and I am transferring that, I am giving the rights to you to manufacture, but in the process, what is important is that IP is valid for 50 years, particularly patents. So the 20 years you have to maintain them. Every year you have to pay a maintenance fee to the government so that the patent is live and active. So once you license this technology to the other party, the question comes, who is going to maintain those maintenance costs? If it's going to cost you, obviously you have to get that money from your licensee. Licensee means the person who is taking license from you. So all these things have to be defined. Otherwise, it becomes a bone of contention subsequently. Obviously, if it is exclusive license, generally the maintenance also will be done by the receiver of the technology. If it is a non-exclusive license, the ownership is not transferred, So basically, the maintenance has to be taken care by the institute who is holding the ownership of the IP. Future developments and improvements. If there are some developments happen, say today is the technology you are transferred, but after few years of research, you came out with a new product or a new development of the existing technology. So whether the person who has taken the technology from you, will he get a first opportunity to get these improvements or the new developments, whether he has to pay extra money, all these things have to be mentioned in the agreement. Infringement. Suppose somebody files a infringement suit on you saying that you have copied my technology, while producing this product. Then how do you address that? But whereas this technology you have taken on license from another university or a institution, they should come and protect you. But unless you define in your agreement in case of infringements, who takes what role, who takes the responsibility of defending those infringements and meeting that legal costs, all these things have to be carefully and captured in the agreement. Otherwise, it becomes a problem. Indemnity is again another important issue. If somebody dies after using that product, after consuming that product, whose responsibility is this? This has to be again clearly articulated in the agreement. You all know during the COVID time, the mRNA vaccine, which India wanted to get a technology to produce in India, and Indian government wanted indemnity because at that time nobody knows whether these vaccines will work, whether they have a bad effects or a good effects. But everybody is in a hurry to save our lives. So based on their plans of the mRNA vaccine, the US company, government of India wanted indemnity. If somebody dies, somebody goes to court after taking that vaccine, whatever damages put, on the company, you need to pay those damages. That is what we call indemnity. You need to indemnify Indian government or Indian administration, for paying such kind of a damages to the people who got affected by taking that kind of a vaccine. So the government, that mRNA company who developed this vaccination technology, they said we cannot give indemnity. So we, Indian government, did not get the technology. Of course, subsequently we developed our own technology, and we also allowed import of the technology from another country, from UK. Jurisdiction for settlement of disputes, that is also very, very important. Force majeure. Force majeure means in case of something happens, which is not in the control of both the parties. It's by act of God, what we call some cyclone, strikes, such kind of things. There could be a delay in achieving the results. So under those circumstances, what are the measures or remedies available for both the parties? This has to be mentioned also in the agreement. And competencies of signatories, the agreement has to be signed by competent people, which are approved by the board of directors of the particular organization. Any organization, is not a one-man company. The person who signs, he should get permission, authorization from all the board of directors who are members of the promoters company, that is also very, very important. In a hurry, many times, what happens, the CEO who signs it, but unless the CEO is authorized by the board, that agreement is invalid. Many times the courts have dismissed such kind of cases, so it's very, very important. These are some of the important clauses or the terms and conditions you should incorporate in your licensing agreements. Very, very important thing, So some patent commercialization statistics, if you see, globally there are large number of patents are being filed every day. But if you look at the commercialization or the licensing of those patents, you see is very pathetic situation. Not all patents have been licensed or commercialized. Not all, at least not even the 50%, According to WIPO statistics dated 2020, India has got around 93,000 patents, valid patents, which are in force, in India. But if you analyze its licensing or its commercialization, it's not that great. According to Google, only 14% of the patents granted in India the last 8 years were commercialized. See, hardly anything, And according to Forbes report, out of the 3.34 million active US patents, hardly 5% have reached the market. About 90% of the patents failed to be commercialized or failed. So this is where, the crux of the matter lies. That is why Government of India has given a highest priority and put IP commercialization is one of the objectives of the National IPR policy of 2016, across the globe, the scenario is not very encouraging, Hardly 10% of the patents only have been commercialized. Of course, there are some exceptions here and there, institutions wise, but globally, the global average is about 5 to 6%. There may be few countries, few institutions whose rate of commercialization is higher than the global average, but the scenario is that not more than 10% patents have been commercialized. So the reasons need to be analyzed, and the policies have to be made in such a manner so that the patents are being commercialized, because patents are basically national assets. After putting a lot of money into research, and this patent, new knowledge, new technologies have been created and rights have been granted, but unless the patents are put into practice and produce the products and services, it is of not much use. It is again a gray area for most of the countries. They are trying, but the current scenario is like that. So this is another important model. The AUTM means Association of University Technology Managers, they proposed this 7-component model, wherein all the components of taking idea to market have been encaptured here. So first and foremost step in the entire process is that invention, disclosure and assessment. That is what we also talked. Any invention has to be first disclosed to the University Technology Transfer Office or the IP cell. What they do? They do the assessment, whether the IP is important, whether it has got a market potential, whether it can bring revenue to the institution or not. If you go on filing all the IPs, it adds, it becomes a debt to the organization. You are wasting money, Unless there is a commercial potential of your invention, there is no point in protecting it, If there is a market potential only, then people will take license, then you will make money. So that is why it's very, very important. It may be novel, it may be inventive, but the market potential is also very, very important in the near horizon. That is very, very important. So all this assessment generally will be able to will be done by the Technology Transfer Office or IPR cell. Once they file the IP, then they market it, broadcast this invention to the all the stakeholders in their own country and across the globe. Then somebody shows interest, they negotiate the terms. So once it is licensed, the startup produces, sells, then the operations are stabilized by capturing the larger market size. They become a market leader in that particular product or a service. So this is a typical model being followed most of the universities and research laboratories when you want to take idea to market. So this is an example of successful university IP commercialization. Say, for example, the companies like, Oxford Instruments, Google, Netscape, Genitech, Polaroid, Lycos, Sun Microsystems, Silicon Graphics, Chiron, Amazon, Cisco Systems, Facebook, all these startup companies, they took birth in the academic environment. Basically, their graduate and undergraduate students, faculty, they all came out with the new ideas and subsequently they become spin-outs and they become startups. Now today, they're all big multinationals, but all these companies have come from academic settings, academic background. So if you see the example of a Harvard University, how the IP management takes place there, IP management, starts with the first step is the invention disclosures, invention disclosures on a year, the university TTO Technology Transfer Office receives around 450 to 500 invention disclosures saying that the faculty, the researchers, they invented something new, that is what we call, if they inform the TTO office, that is what we call invention disclosures. See, once you receive that, the office of Technology Transfer Office, they evaluate and they decide how many number of applications to be taken to for filing or protecting the IP. On an average, around 50%, have become the candidates for filing patent applications. And they have filed
నైస్కి వెళ్ళిపోతున్నాడు ముందుకి హైలైట్ అనిపిస్తుంది. ఇంకా తర్వాత మిగతా అబ్బాయిలందరూ చూస్తే కొంచెం ఊపిలోనే ఉన్నారు, ఆడుతున్నారు.
Mr. Vara Bhavani, please mute yourself, don't disturb us. Okay, 50% of the invention disclosures have become patent applications, and out of 50%, around 50% have become patents granted on a yearly basis, Then out of that 50%, another 50%, 40 to 50%, have become licensed, the patents have been licensed, in the form of IP licensing agreements. On an average, around 45 to 50, they are able to license those patents. So once licensed, what happens? Commercialization takes place. And they also get royalty and also licensing fee. On an average, they were getting currently around $100 million US, 100 million US dollars means how many? Lakhs, 1 US, 8 crores or 8.3 crores. So 100 means about 800 to 900 crores they are getting as a licensing fee from their university technology patent commercialization. Apart from that, they were also able to launch around 15 to 20 startups every year from their own IP, what they have created in the university. So broadly, these are some of the important aspects. But if you look at the challenges, for IP licensing or IP commercialization in our Indian scenario as well as the global scenario, the major challenge is that, if you want to license IP, it should be fairly at a developed stage. But most of the patents, what we are filing and what we are trying to license are having low levels of technology readiness level, TRLs we call it. The technology readiness level is measured over a scale of 1 to 9. If it is 6 and above, the TRL level 6 and above, what we is the ideal stage for licensing. But most of our technologies are below TRL 6, mostly TRL 3. That means proof of concept. They are at the proof of concept. So when they are at the proof of concept, they are not developed in the form of a prototypes, validating the prototypes at a commercial scale, if you license those kind of IPs, generally the failure rate will be higher. That is one reason why the patent commercialization, across the globe is very low, less than 10%, because the development stage is very low. It should have been at TRL 6 and above, but most of them are below TRL 6. That is one of the reasons. And lack of funding for scale-up and pilot plant studies. How do you raise the TRL level? It is possible only by scaling up that production unit, from the laboratory to bench to pilot to semi-commercial, then commercial. So most of these studies requires a lot of funding. So there's not much funding is available, and that too we need risk capital. We are not sure whether we are successful in our endeavor or not. So risk capital availability is very limited in our country, and limited market validation field testing. 99% of our technologies which were developed in the academic environment, particularly, they were never field tested. They were only tested in the laboratory. And lack of market research studies, for commercial assessment is also not being done. If you wanted to be successful, you should know the market conditions for that product or service, whether there is a market for that, whether there is a demand for such kind of products or not. So limited access to risk capital is also another issue. And inadequate IP awareness, lack of IPR protection is also very less. See, countries like China, US, there is a huge awareness there. They file large number of patents every year. For example, China files 15 lakh patents. To India, just now we reached about 1 lakh patent filings in our country. Where 15 lakhs, where 1 lakh. In terms of population and all, we are in fact much ahead of the China now. But our rate of filing of patents itself is very low because of lack of awareness, lack of resources, the limited technology transfer commercialization professionals. This is why it's very, very important for all of you, that is why our Honorable Vice Chancellor in his wisdom and vision introduced this course of IPR in Andhra University. No state university teaches IPR as a mandatory credit course because of such an important subject. Our Honorable Vice Chancellor Prasad Reddy has introduced this course for the benefit of all of you, so that the human resources produced out of this university will be coming out with the access to such kind of a knowledge and understanding of IP creation, protection, and commercialization. You all agree with me that IP is very, very important for our socio-economic development. Whatever products, whatever services humanity is using, they are all based on the IP creation, IP protection, IP commercialization. You name any product, all the products are protected by intellectual property rights. But only thing is, we do not aware the importance of IPR. Simply we are buying and using. So whenever we buy a product, for example, you are buying a smartphone, say for example 30,000, 40,000. In that, at least 10% goes to the inventors who invented those technologies embedded in the phone. So that is the kind of a impact these technologies can make on the society and also to the inventors. The lack of legislative support is missing, complex regulatory compliances, inadequate incentives for inventors and innovators, higher technology transfer fee. Suppose somebody wanted to import a technology, it's quite expensive. So no national guidelines for IP valuation. Patents are not technologies. Most of them are proof of concepts. So low patent commercialization is about 5 to 7%. So as a result, the commercialization of patents are very limited, not only in India, even across the country. So I would like to give one example here. This is simple Coca-Cola can, the opener. The opener, what we see on the Coca-Cola can, this is a great patent invented by one UK gentleman. He licensed this technology to Coca-Cola and other soft drink companies. He charges 1/10 of a penny per can. You open, he gets as a royalty. So that 1/10 of a penny means, such a small amount, 1%. But if you see the kind of amount, the kind of money he gets as a royalty is about 1,48,000 pounds per day. 1,48,000 into about 100 rupees average approximately, he gets 1.5 crores every day as a royalty from this technology, as long as this technology is in force. Do you think we don't have that kind of an intellect with us? We are much more intelligent than anyone on this globe, on this earth. But only thing is, we don't apply our mind, we don't seek protection for our knowledge. So this is such a simple technology which fulfilled all the three criteria of novelty, inventive step, and industrial use. And he got protection for this patent and licensed it to the industry and making tons of money for himself and his country and his family. So this is what is important, is that kind of a curiosity, recognition, and trying to acquire rights on that. And in our country, we have a called National Research Development NRDC, National Research Development Corporation, for which I served as a chairman and managing director for about 5.5 years. There we licensed several technologies, IPs, patents, developed by the national laboratories and universities, more than 5,000 technologies, we licensed and commercialized through NRDC. So this is a standard model we follow there at NRDC. So what we do is that, the laboratory technology, we identify the laboratories who have got potential technologies, can be used by the society. Then we identify the common areas of interest. We sign an agreement with them. For example, Andhra University is there. NRDC signed MOU with Andhra University and evaluate all the technologies of the patents of Andhra University. You might be knowing now, Andhra University during the last 2 years, we filed 100 patent applications. We got almost 100 patents now in the name of Andhra University. So we may not be able to license on our own these technologies. That's why we signed an MOU with NRDC. NRDC is helping us and this, Baswani, Gautam, whoever is disturbing us, we are noting their names and their internal marks will be cut to that extent. Please, if you want to talk, mute yourself and talk. Don't disturb us. So we evaluate the technologies, NRDC evaluates, and if there are any gaps in the technology in the form of a IPR protection, prototype development, field testing, market research, basic engineering packages, techno-economic feasibility report preparation, regulatory dossiers, publicity, funding, seed funding and angel funding. These are all the basic elements, which matures the technology, which minimizes the risk, in commercializing these technologies. So NRDC provides all these kind of services depending upon the gap available in the technology and the market, and they identify the technology receiver, and with them they negotiate the terms and conditions of licensing, what we discussed. Then there will be an agreement signed between the lab, the university, NRDC, and the company who is interested to take this technology. Then you demonstrate the technology and transfer the technology to the company by way of demonstration, by way of providing technical know-how packages, and holding consultancy, all those things. Based on that, they establish a venture on the company, and the NRDC and the laboratory of the university will help the company in establishing a commercial plant and stabilizing the commercial operations. Thereafter, they evaluate the successful commercialization. To what extent the technology licensed was successful in terms of wealth creation, profits, and taxes paid to the government, employment opportunities created. So this is a standard model. Most of the countries follow the same kind of a model. And if you look at, as I told you, NRDC has licensed more than 5,000 technologies. Some of these technologies like indelible ink, when you go to elections, they put the ink on our finger to identify you already voted, you cannot vote for the next 3 to 4 years. So such kind of an ink was developed by one of the CSIR lab, NPL Pune, NPL Delhi, National Physical Laboratory, and that technology was licensed by NRDC to one company in Mysore. That company, even till today, they are manufacturing and selling and exporting this ink to many countries, also making huge money. Amul baby milk powder is another big technology licensed to NDDB by NRDC. The tractors, Swaraj tractors technology was licensed. So like that, thousands of technologies were licensed by NRDC to SMEs, large companies, startup companies. The Some of them are listed there. If you go to the website of NRDC, you will get a lot of information about this. But finally, what I would like to say is that if you want to achieve successful IP licensing, you need to see at the time of licensing, signing an agreement, whether all these 10 critical parameters are existing in the entire transaction. In that transaction, if these 10 parameters are prevailing in a great strength, that technology is bound to be successful. So what are those 10 critical parameters? If you want to achieve successful IP licensing, you should have a large market size for your product and service. The market research is very, very important. The commercial potential of the product or services assessment is very, very important. So you need to assess before venturing into IP licensing, the market size, the market competition, that's very, very important. Easy access to finance is again another important because they're all innovative technologies. The risk possibility or the failure probability is very high. Unless you get a risk capital, like venture capital fund and all for commercializing these new technologies, again, the technologies are not bound to be successful. So easy access to finance is very, very important if you wanted to achieve IP licensing, successful IP licensing. Strong IPRs is also very, very important. The claims of a patent determines the strength of the technology. So the strong IPRs are very, very important. Field tested prototype, you need to test. You should have field tested before launching into a commercial production or taking a license. If the technology is already tested at the field level, then the possibility of becoming a successful enterprise are great. Techno-economic feasibility or viability establishment is very, very important. Performance guarantee of the technology. The person or the institute, whichever is transferring this technology, they should also give a performance guarantee that also minimizes the risk. Competitive price and quality of the product or service is very, very important. Product meeting the user needs is essential. Fiscal incentives by the government, like why the solar technology has become so successful in a very short time in our country is that now government is giving a lot of incentives, for adopting solar technologies. And of course, having competent team at both the sides, the transferer side and the receiver side, the same passion, same energy level is very, very important if you want to achieve technology licensing. So Andhra University, as an example, we always give, the IP licensing and IP commercialization, we started, paving the way for achieving greater success in this space of IP creation, IP protection, IP commercialization. So Andhra University established the Center for IPR or TTO with the help of Government of India in the year 2020-21. A competent team and resources are in place now. We brought out AU IP policy. The policy is the very, very important, basic document which gives the direction, which gives the authority, We brought out the AU IP policy, which is also was kept on the AU website. People, all of you should read that, to understand what do you mean by IP policy, it should be within the framework of the national IPR policy. So we established a incubation center as another major contribution of the present Honorable Vice Chancellor. They established the incubation center. People, students, faculty, anyone has got a new idea, they can convert that idea into a product or process using the services made available at the AHub AU Incubation Center. We also brought out a compendium of AU patent portfolio for marketing. All this list of AU patents were kept in the AU website. Now, as I mentioned to you, we have about 100 patents now. Interested entrepreneurs can exploit them, use them, take license from Andhra University and produce those products and bring it to the market. We already started commercializing one patented technology, developed by the biotechnology department, the portable biosensor for detection of type 2 diabetes. Akshaya Inotech is our startup company in Visakhapatnam, have taken license, for producing this portable biosensors for detection of type 2. So I would like to conclude saying, IPR is a bridge between academia and industry, and the IP means is the knowledge presented by Goddess Saraswati, and put that IPR into practice. That means commercialization, it creates wealth. So these two forces only drives the entire human development, Goddess Saraswati and Goddess Lakshmi. people who acquire knowledge, who acquire qualification, education, they can think differently, they can bring a lot of innovations, to the society, and using that innovations, the industry can produce wealth, employment opportunities, thereby contribute to the socio-economic development. So if you are able to manage these two forces effectively, the knowledge force and the wealth creation potential of the knowledge, definitely those nations, those countries have emerged as a global leaders and economic leaders. You have seen this, countries like US, Japan, Germany, China, they are able to manage these two forces. They are able to maintain equilibrium between these two forces. As a result, today they emerged as a global economic powers. I think now we also started to have such kind of a policies. Now, if you see the difference between now and 10 years down the below, lot of transformations have taken place. Lot of the very case of institution of IPR chair in Andhra University is an example, live example, how transformation is taking place, how developments are taking place. So it's all up to you how you make use of the expertise available in Andhra University, acquire more knowledge on IPR, come out with new ideas. I advise you are all in the second year, by the time you come out as a graduate or a postgraduate of this university, you should file at least one or two patent applications. Whatever projects you are doing, or if you have got some new ideas, convert those ideas into prototypes or a proof of concept. They are eligible for securing IP rights on that. Not that you will be able to convert them as a products and establish companies, but you will understand various steps involved, processes involved in creating a knowledge, protecting the knowledge, and commercializing that knowledge. I would like to end up my talk here today. And if you have any specific questions, I would like to spend maybe 5 minutes, and hope to see you before end of this course. Almost we are midway in completing this course, and we are located in AU Computer Center near the Registrar's Office, Controller of Examination Office. So you people can come, visit us, seek any doubts, clarifications from us. We are always available with you. Thank you so much. If you have any specific questions, you can ask. Otherwise, my colleagues, Dr. Anandya and Ashok, they are there. They will answer your questions. Thank you so much. Any one of you have got any questions? Please quickly. Otherwise, yeah. Dear students, as per the schedule of the class, there will be examination now. Yeah, assignment examination. 5 minutes, so we'll be posting the link in the group. All the CRs should forward that link to all your students or your classmates, and you should submit that assignment by end of this day. People who could not submit before end of this day, they will get 0 marks for that. Okay, please follow the instructions given by my colleagues.
ఎప్పుడు వెళ్ళలేదు ఎప్పుడు
అతను